September 11, 2001 dawned like any other day, but by evening, the twin towers of the World Trade Center lay in rubble and nearly 3,000 were dead. It was a defining moment. The world would never be the same. We quickly took important lessons from the tragedy, terrible as it was. Airport officials admitted a 9/11 could have happened almost any time, long before, with security so lax. Within weeks, President Bush signed TSA into law, and you could no longer stroll through an airport to your gate. IDs, boarding passes, search bags became mandatory. Security screening was immediately put in place here at the Texas Capitol. Those changes and many others became normal. The new normal we now take for granted. COVID-19 struck, not as suddenly, but unrelentingly, wringing from us life and routine month after month, with more than 100 million cases and 1 million deaths in the United States to date. The pandemic was historic, a defining moment. The world will never be the same. That's certainly true of the justice system. Texas courts kept their doors open, with participants joining proceedings remotely to minimize health risks. We've had to learn how to Zoom. We've had to learn how to do jury trials in make-do facilities and to reduce backlogs. We've had to learn a lot. Former Michigan Chief Justice Bridget McCormick put it well. This pandemic was not the disruption we wanted, but it might have been the disruption we needed in courts to accelerate change in a way that can produce a justice system that's more accessible and more transparent and more efficient. America's civil justice system is still, after 85 years, very much a product of the Federal Rules of Civil Procedure in 1938, which are foundational in Texas and most other state courts. Our criminal justice system is deeply rooted in the 19th century. If we sat down to create a 21st century justice system from scratch, it would bear little resemblance to the system we have. Lawyers and judges resist change, and to their credit, stability and predictability are virtues. But obstinacy is not. In my 2019 State of the Judiciary, I reported that Texas 3,200 judges had resolved 8.6 million cases the prior year, 23 times the number of cases handled by all the federal courts put together. In a small fraction of those, maybe 0.5%, procedures designed for felonies and complex civil cases assured justice. For the remaining millions of more straightforward cases, which also sought justice, those same procedures impeded a fair, cost-effective, and efficient resolution. We have long known our justice system ill-fits present realities. The public complains that going to court takes too long and costs too much. Our response has been slow and muted. By contrast, the marketplace turns on a dime. When COVID prompted many households to want food delivered to their doorsteps, the market immediately responded, offering all sorts of convenient, reasonably priced food delivery systems, not simply insisting that people go to stores. The contrast between the justice market and economic markets is jolting. If the justice system were a business and its customers had any choice, it would be in bankruptcy. The pandemic is, and we must see it as, a defining moment, like 9/11, an impetus for innovation and change. And I don't mean change for change's sake, and I certainly don't mean change for the worse. But we have long known that improvements can and should be made, and we have not adequately responded. Now should be the time for taking stock and taking action. Never, in the words of Winston Churchill, never let a good crisis go to waste. As Chief Justice of the Supreme Court of Texas, I'm required by law during each regular legislative session to report on the state of the Texas judiciary. This is my 5th occasion to do so. Last time, in 2021, I concluded by saying, we will defeat the pandemic. We will return to normal. For the judiciary, it will be a new normal, one with even greater promise of justice for all. We are hard at work to fulfill that promise. We are gaining on it. The first measure courts took to stay open in March 2020 was to conduct proceedings with participants joining remotely by electronic means, usually Zoom, a rarity before that. Within a year, Texas courts had conducted almost 1 million Zoom hearings with more than 3.5 million participants. Courts use Zoom simply to keep dockets moving amidst health risks of congregating in person. What we did not expect, even though we should have, was that if parties don't have to take off work, arrange for childcare, travel across town to a courthouse they have no other reason to visit, and spend hours waiting for their case to be called, just for a few minutes to try to protect their rights, they will show up much more often. Some trial judges reported that participation rates in high-volume dockets, like child custody and traffic cases, flipped from 80% no-shows to 80% appearances. A legal system that would knowingly structure proceedings to make participation impossible for those most affected should be ashamed of itself and should change. Electronic participation is not right for every proceeding, like most jury trials, for example. And losing the benefits of in-person exchanges and the experience of the solemn awe of the courtroom, surrounded by our forebears, that carries its own costs. But for many hearings, the efficiencies clearly outweigh the drawbacks, and electronic participation has become standard procedure. It would be virtually impossible, for example, for visiting judges and lawyers willing to assist small counties at the border with the increased dockets of Operation Lone Star if they had to travel across the state. To bring structure and uniformity to this developing practice, the Texas Supreme Court opted new rules of Civil Procedure 21D and 500.10 and amended other rules effective February 1st. The rules set out when courts can permit or require participation in court proceedings by electronic means and the factors to be considered. The rules are the product of lengthy discussions among judges, lawyers, and the public with legislative input. They balance the benefits and detriments of electronic proceedings, and they can be nimbly modified as we gain more experience with the new normal in the justice system. The rules provide a solid foundation for its development.